All right, are you Quentin Sells? So, Mr. Rojas, you've been appointed to represent Mr. Sells. Is there any reason to believe that the person standing before me is not Mr. Sells?
No, Your Honor.
And so I'll take judicial notice of that, as well as the court's file, including a report. Mr. Sells was evaluated for competency to stand trial by Dr. Hamza. I have received that report dated November 14th of 2025. The finding is that Mr. Sells is not competent to stand trial at this time. Is there any other evidence with regard to competency?
No, Your Honor.
Not from the state, Your Honor.
Then at this time, based on that evaluation, I am going to find that Mr. Sells is not competent to stand trial. I'm going to order inpatient treatment at the appropriate facility for a period of not to exceed 120 days from the date he gets to that facility, and then we'll await a report from that facility. He can go back with the bailiff.
No, go on. I'm not
We're going to get you, we're going to get you some help, and then you can come back and take care of your case, okay? Go back with the bailiff, okay?
Bailiff for what?
Right there, go back, go to the back, okay? Go to the back. Good morning, are you Kashawn Purdy? And Ms. Purdy is on probation and cause number 24, DCCR 1272 for the state jail felony offense of unauthorized use of a vehicle. And there's a new indictment in cause number 25, DCCR 1523, charged with injury to a child, elderly, or disabled individual. Mr. Kimler has filed a motion asking for a bond in that unauthorized use case that has the motion in it. Mr. Kimler, you may proceed.
Your Honor, I think she's on deferred. I've reviewed a little bit. I haven't actually gotten discovery on the new case yet, but I have reviewed some photographs that were taken by the defendant's family with injuries. I don't want to downplay it, but it appears to be sort of the minimus type of injury. It's not, and I'll defer to Mr. Hawkpower, may have a different opinion on that. We're simply asking for a bond on the underlying motion to revoke probation to allow her time to prepare to defend the injury to a child case.
I can't, hold on. Y'all, I'm having a hard time. So if you're talking about a case, for some reason, I'm having a hard time. I've got a cold and my ears are stuffy. Y'all need to step in the back. If you're not talking about a case, I need you to really be quiet.
And I'll try to
Speak up, please.
And additionally, she is pregnant. I think that, and I did receive a write-up from, that was emailed to me from the jail. And to the best of my understanding, it appears she was wearing, I guess, a blue wristband to indicate that she's pregnant. There was some, I don't know, misunderstanding on the part of the jailer as to whether some other female inmate had given her the wristband. Evidently, they get extra rations or extra portions of food and their vitamins and stuff if they're pregnant. But it appears from the write-up that she actually is pregnant, so I don't know that it was a disciplinary write-up or what the purpose of the write-up is, but she certainly, other than that, hasn't had any problems to my knowledge.
All right, you want to put on some evidence with regard to her ability to pay? Would you raise your right hand the best you can? You swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Ms. Purdy, the judge just wants to know your ability to pay a bond, to actually come up with the funds necessary to pay a bond when you get out of jail. What's your financial situation right now, just generally speaking?
I had got laid off back in September, but I had got another job at the end of October, so I'll be able to pay my bond.
How much do you have available now to pay a bondsman as far as money that's put aside to pay a bonding fee to get out?
Like 500, 600.
Okay, and then hopefully after that you get your job and would be able to work?
Yes, sir.
Okay.
Yes, sir.
Do you have any savings or checking, money in the bank, anything like that?
No, sir.
Do you own your own residence, your own home? Do you own your own?
Rent, yes, sir.
You rent? Do you own any vehicles?
No, sir.
What about any other thing of value that you might own? Anything?
No, sir.
That's what it is.
I need to know, how many children do you have?
I have 2 and 1 on the way.
And where do they live, with you?
Yes, ma'am.
So if you make bond, where are you going to be living and with who?
At my home.
Who lives at your home?
Me, my 2 kids, and my fiance.
Did Child Protective Service get involved in this?
Yes, ma'am. They closed the case. And I was also taking anger management and parenting class also.
Through CPS?
Yes, ma'am.
But you didn't finish those because you got incarcerated?
Yes, ma'am.
Okay.
Right.
What's your relationship with Kamari?
It's my oldest. I talk to her every day. She tells me every day, she say, Mama, I'll pray.
I don't
for
care,
you."
Yeah, just answer the questions.
Yeah.
because you're not gonna be allowed to be around them if you may bond. So you gotta figure something else out until I figure out what's going on with your
Yes, ma'am.
case. So that's gonna be, who are they with now?
My mom.
Okay. So if you make a bond, then they're gonna have to remain there. You're not gonna be able to have unsupervised contact with them until further order of the court. Do you understand? That would be a condition of your bond.
I totally understand.
Okay. Mr. Hoffpower, what's the state's position?
Judge, that was our concern, is the new offense. I disagree whether or not it was de minimis or felony court.
Well, and for the record, I am reviewing the probable cause in that case, just to get a little bit of information on what the allegations are.
I was talking about a photograph, so.
What else?
Simply judge that she's on felony probation and allegedly commits a felony. We'll leave to the court's discretion.
All right, so I'm going to grant the motion to set a bond in cause number 24 DCCR 1272. I'm going to set that bond at $30,000. A condition of that bond is that you have no unsupervised contact with any children, including your own, and that you complete whatever CPS is requesting that you do. So if they started classes, you need to continue with those and whatever they request of you. Do you understand?
Yes, ma'am.
All right.
A lot of secret.
All right, you can go back with the bailiff. Good morning. Are you Deshaun? Is it Vital or Vital?
Vital.
Vital. And Mr. Lewis, will your client waive the formal reading of the indictment in each case?
He does, Judge.
Mr. Vital, in cause number 25 DCCR 1107, you're charged with a first-degree felony offense of aggravated robbery from July 10th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Freely, yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then in cause number 25 DCCR 1109, you're also charged with a first-degree felony offense of aggravated robbery from July 10th of 2025. And how do you plead in that charge?
Guilty.
And are you pleading guilty freely and voluntarily? And again, because you did what they charged you with. In both of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for a 10-year deferred probation, that ISF would be ordered. So when is your 18th birthday?
April 8th, 2000.
Okay, so it'll be less than that at sentencing. So we'll do upfront time until your birthday, and then you would go to ISF. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Vital is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of guilty in each of your cases freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. Find sufficient evidence to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. So are you at Minnie Rogers or at the jail?
Judge, can I address something?
Yeah.
Obviously, Mr. Vital has been in custody for several months. He's going to continue to be in custody for several more months. While he's in Jefferson County Correctional, he's mentioned multiple times in reports, typically he's a victim of other people's behavior. There are a couple instances where he's doing things he
Yeah, I don't
shouldn't do,
see
but
many at all.
it's not the worst of the worst. It's not my concern. I just wanted to explain to him that it's important. And the last note I saw was that he'd been moved out of a dorm where he was being victimized.
Yeah.
And bullied.
Yeah,
I want him to be successful. I want him to
I
understand
do
that
too.
those reports can change, what gets reported between now and sentencing can change what happens in this case.
sure. Thank you, Mr. Nichols. And I was going to address that. And you may have heard out there already that incident reports at the jail don't go over very well with me. I do understand there's been some things going on that weren't your doing, and so you just keep doing what you need to do to keep your head down to make it until we get to sentencing so that you can be successful. You're doing the right thing. If we end up with some reports and you change your behavior, which I don't see any reason to, you've been doing pretty well. And it sounds like the jail has taken notice of what's going on and where you need to be. But just continue doing what you're doing so that when we get back here in a few weeks for sentencing, I don't have any issues and Mr. Nichols doesn't have any issues to look at with regard to jail incident reports, okay? All right, you can go back with the bailiff. Thank you. Do it on a different day. Yeah. Okay, you're Michelle Cormier,
Yes, ma'am.
and will your client waive the formal reading of the indictment in each case?
Yes, ma'am.
Ms. Cormier, in cause number 25, DCCR 1446, let's see, are we going on with the prior or just the?
With the prior judge.
Okay, let me, you're charged, hold on. You're charged with manslaughter from November 2nd of 2024. It's a second-degree felony. The indictment alleges you were previously convicted of burglary of a habitation, a second-degree felony, January 30th of 2013. And how do you plead to that charge? And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they've charged you with? And is that prior conviction true?
Yes, ma'am.
Okay. Sorry, it takes me a minute to get it pulled up. In cause number 25, DCCR 1447, you're charged with possession of a controlled substance, a state jail felony from October 30th of 2024. The indictment alleges you were previously convicted of possession of a controlled substance, a state jail felony, January 30th of 2013, in two different cases, or three different cases on that date. And what that means in that case is that would be enhanced to a third-degree felony. Do you understand?
Yes, ma'am.
And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And are those prior offenses true?
Yes, ma'am.
In each of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Radford?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And so there's no agreement, correct, in either of the cases. So I want to make sure you understand that you have an absolute right to have a jury come in and determine two things. The first is to determine if you're guilty or not. And then if they find you guilty in the case, you could leave your punishment up to that jury. If we go forward this way, you're leaving your punishment up to the court. And is that what you want to do?
Yes, ma'am.
State tenders number 1 in each case.
No objections.
It's admitted in each case. Is there any evidence that Ms. Cormier is not competent?
No, ma'am.
All right, ma'am, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your case for a sentencing hearing. We'll get a pre-sentence report done, and then we'll come back for that hearing. Anything that you think is important for me to know, get that information to Mr. Radford, and he will present it to me on your behalf when we come back.
Judge, we're gonna have some letters that I will submit to the court to supplement the PSI, and I will copy Mr. Coleman on those support letters.
Okay, sounds good. And if you'll just try to get those to the court that week before
Yes, ma'am.
The hearing, that would be great.
Yes,
All right,
ma'am.
thank you. You can go back with the bailiff.
I'll be excused.
Yes, sir, thank you. Good morning. Are you Raymond Sweet?
Yes, ma'am.
And Mr. Sweet, in cause number 25, DCCR 1531, you're charged with a first-degree felony offense of burglary of a habitation with intent to commit another felony, and that's from August 22nd of 2025. Your indictment alleges you were previously convicted of burglary of a habitation May 28th of 1987, and also burglary of a vehicle on that same date. And then after those were final, you were convicted of robbery April 20th of 1988, and also burglary on that same date as well. And then after all of those were final, you were convicted of aggravated assault of a correctional officer June 8th of 1992. What that means is that if you go to trial and you're found guilty and those prior offenses are true, the range of punishment in your case would be between 25 years and up to 99 years or life. Do you understand? And I have a plea bargain rejection here on the tablet that you've signed with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 30-year term in prison. You have every right to reject that offer and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial? I'll get that done. I do want to make sure, Mr. Smith, is there any reason to believe that there's any other evidence or that offer would change?
It's not going down.
So I want to make sure you understand that I will not accept that offer after today. If you change your mind and you want to enter a plea of guilty, then it would be to something different or open to the court. Also, so do you want to go forward with trial?
Yes, ma'am.
Okay. Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint someone else today who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
So, Mr. Rojas, you're released. We will appoint someone today. They should be out to see you very soon to begin preparation for trial. All right, you can go back with the bailiff. Yes, sir. Robert Felix, what are you going to do?
Hey, can we hold on for a little bit? We're
Yeah,
trying to get over
that's good.
questions.
And then what about, we got an incompetent. Let's see, I think I can get that done maybe, well, I hate to get in the middle of it. I feel like I'm on one in the background, that's why. Hold on a minute quick. Good morning, are you Isaiah Brown? Will your client waive the formal reading of the indictment? Mr. Hoffpower, this is yours on Isaiah Brown.
Sorry.
Okay, so it's a reduction to state jail.
Yes, ma'am.
Okay, Mr. Brown, in cause number 25, DCCR 0356, the state has elected to proceed on the lesser offense of a state jail felony, abandoning or endangering a child with intent to return from February 9th of 2025. And how do you plead to that charge? Speak up. Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? Answer out loud.
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Brown is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that we can get a pre-sentence report done by probation. Then we'll come back at a later date for sentencing. Mr. Hoffpower, what is the state's position with regard to a bond based on the nature of this plea?
We have no position.
What is the,
Just a-
what's the relationship to Kinsley Segura?
that's
Mr. Charles,
Child.
this is
It's your daughter?
No, he's not with the mother, you know.
I'm sorry?
They have custody. I'm not sure if he, what kind of.
Do you have any kind of,
No, she blocked me when she had my baby, so I'm not on the birth certificate, I'm not on none of it.
so until anything happens legally with that, you cannot have any contact with your child, you understand?
Yes.
Okay, so what I'm going to do, based on the nature of this plea agreement, between now and sentencing, is reduce your bond in your case to $1,000. If you make that bond, it's very important that the first thing you do is go to the probation department so they can start that pre-sentence report, okay? Also, a condition of that bond is that you have no contact with Kinsley Segura, okay? And then we'll see you back at sentencing. All right, you can go back with the bailiff. Good morning, are you Braxton Hughes? And this is 25 DCCR 1124. Mr. Hughes was previously in court, entered a plea of guilty to burglary of a habitation. The agreement was for a cap of 4 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Are there any additions or corrections?
None aware, Judge.
Obviously, I'm aware of some of his criminal history, others not quite so much. I would think that the 4 would probably be on the low end in your opinion, but I would defer to whatever you think.
Okay, thank you. Mr. Parker, you may proceed.
Your Honor, I mean, I've talked to him and I've heard some stories in my life, but I feel that he's telling the truth, not that it's a defense, but they were getting pulled over. He had some other guys in the car. There was drugs in the car. They took the drugs. He leaves and goes to a house that he used to know the person that lived there. He walks in, gets him something to drink and has a thermos or something like that. And then turns around and she stayed in there. He had obviously scared her and, and didn't know it and it wasn't the person he knew that lived there. And he said, call the cops, and he walked outside and sat down and waited for the cops to show up. And that's what happened. It's not like he was going in there, to try to injure her. I don't think. He walked in the wrong house and he did take the thermos or mug and it's simple as that. I think he'd like to talk to the court, Judge. And we're asking for probation, Judge.
All right, go ahead, Mr. Hughes.
Your Honor, what he said is correct. I can't say anything else. I was doing drugs about a year and a half, but I was like a lightweight. I took the drugs and was not really acting like myself, and I went and knocked on the door and went in there. I was trying to get away from the people I was with, but long story short, after this event, I did sober up. Started going back to church with my mom. I was in for treatment at the Right Step. I tried to get into treatment there. I was doing the paperwork there, trying to get help, but I was sober for a couple months out there on the streets, and I'm not really like a typical druggie type. I don't go around commit crimes or nothing like that.
Your criminal history would say otherwise.
This has been a long time.
I understand, but be careful how you word things because you've been a criminal since 2002. You've got 1, 2, 3, 4 misdemeanors. You've got 1, 2, 3, 4, 5 felonies. Many more that you were arrested for, and obviously doing some things that you kind of got either rejected or dismissed because of pleas on other stuff. So I understand that some of those were a long time ago, but it's still not a pretty picture.
I understand that. You know, most of my previous crimes and stuff, they were behind addiction and stuff. But, you know, life's a journey, and I haven't, you know, I still was battling with addiction, but not committing crimes. You know, that, you know, this, I know, with the standing here in front of you, you know, charged with the crime, I could understand, you know, how it's on.
Yeah, I mean, and it's, at what point do you go get that help before you commit a crime, you know? I do appreciate what you've done since the offense, Ms. Malfino.
Judge, I would definitely agree that this is an odd fact pattern, very odd. I feel sorry for the situation that he's in with his addiction, but I feel more sorry for the young lady who was scared out of her mind when he was in her house, acting probably like a complete psychotic animal with tinfoil on his head. So I don't know that probation at this juncture would be a viable option, Judge, or a good thing for the community, but I defer to whatever you think is best.
If your history had, one of the things that is sticking out is that every probation you've ever gotten has been revoked. So you've never been successful on probation, and so.
Completing the last one.
Huh?
I did complete the last one.
The last one that I see was the federal
Yes, ma'am.
sentence where your supervised release got revoked.
I did get revocation, but I got back out on probation and completed it.
Okay. At this time, Mr. Hughes, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. Sentence you to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, you can go back with the bailiff. And this is Ms. Malfino. I don't usually, unless this is one that I would potentially consider.
Right.
All right, you are Kadesha Eli, and Ms. Eli was previously in court, entered pleas of true to a motion to revoke probation on probation for injury to a child, elderly, or disabled individual. Entered pleas of true to counts 1 through 8. I've received an updated report. Has everyone had an opportunity to review that report?
Yeah.
Are there any additions or corrections?
Nothing to finish.
Come from the state, Your Honor, unless Ms. Lopez has anything additional to her updated PSI.
All right, thank you, Ms. Lopez. And there was not an agreement, correct?
Correct.
Mr. Lewis, you may proceed.
Well, Judge, Ms. Eli, like I said, was previously placed on probation out of this court. Early on during her probationary period, it seems she'd been doing really well, doing well, of course, being able to comply with the terms of probation. During that time, of course, she started having personal setbacks as far as her living situation, as far as where she would live and things of that nature. I believe at some point she did talk with probation about that, as far as trying to get some help with that. And it seemed to be working out well, even gotten to, I think she was living with your mother, your grandmother. And seemed to try to get back on track, but at some point that situation didn't work out for her either. And that's when things started to really go downhill fast as far as the not reporting and things of that nature. And it snowballed on her. Since she's been in custody, she has been able to secure a more stable living situation, of course, with a brother that will be available to her if the court decides to reinstate her. Also, employment. She has some employment options that's available to her as well. That I think that was her main problem or issue was stability. And I think since during this time while she was already searching for these options, Judge, but they unfortunately by the time they became available to her, she was in custody. Now, when I talk about the situation with her brother for the living situation, that's also one of the job situations as well. Her brother works with Zumo Sausages, the Zumo company, and she actually worked there for a temporary period of time a while back early on. And that job fell apart, but looks like it'll be open again for her to go back. So that's essentially what it comes down to. She's asking now that she's stable to try to see if she can have the opportunity to get out there and complete the probation like she initially tried to and wanted to.
What's the status of the theft in Orange? The new offense?
For as we know, the situation in Orange, there hasn't been a court date or anything up there. So it's still in limbo,
But
at this point, Judge.
Okay. Ms. Malfino?
Judge, I think it's fortunate that we're not here on a violation that involves a child based on the underlying nature of this probation. But I also think it's unfortunate that she doesn't have any felony offenses, was given this many opportunities, and as this court is well aware, a very good officer to work with in Ms. Lopez, and she has not done what she has been required by this court to do. So I would stand with Ms. Lopez's recommendation and defer to any other comments she might have.
So, Ms. Eli, the problem that I have is that when you first got on your probation, we sent you to the cognitive track of ISF so that you could get tools to be able to be successful and do better and make it through probation. And when you got out of ISF, you were put on the high-medium caseload so that you would have help with all of these issues that Mr. Lewis is talking about. Help with places to live and with jobs, and you were given all of that. And so for me to say, okay, you've already been given all that and you didn't take advantage of it to give you some other opportunity and just let you out when I've already given you these sanctions, and the underlying case is just very, very serious, and the fact that you got a probation was a big chance. And if you hadn't already been to ISF, then maybe I'd be thinking about, okay, let's do ISF, or let's do something to give you some tools to do better. But we did that, and you didn't take advantage of it. So at this time, I'm going to find that you entered your pleas of true to counts 1 through 8 freely and voluntarily. Find those counts true. Find sufficient evidence at this time to find you guilty, and at this time find you guilty of the offense of injury to a child. Sentence you to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. This is not a plea agreement, and so you do have some rights to appeal. You can talk to Mr. Lewis about that. I'm handing you the trial court certification. It shows you do have that right to appeal. I need your signature on that, and I'll get you a copy of it. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, you can sign that, and y'all can take the bottom 2 copies.
should be a second amended motion to revoke. You have a second amendment?
No, I'm on the first amendment.
You have that second amended one was filed.
I could print out a copy.
I have the date that it was filed.
It looks
There's
like
a
August 27th. So it should be the one that you have, but let me print it just to, Good morning, are you Leonard Guillory?
Yes, ma'am.
And so, Mr. Guillory, let's start with cause number 25. Is it printing? Hold on, I can't. Yeah, there it goes. All right, in cause number 25, DCCR 0902, you're charged with aggravated assault with a deadly weapon from June 19th of 2025. The indictment alleges that you were previously convicted of a felony offense, which means for punishment purposes, if you were found guilty, you would be considered a first-degree enhanced, and the minimum punishment would be 15 years up to 99 years or life in prison. Do you understand? And I have a plea bargain rejection here on the tablet that you signed with Mr. Lewis that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 10-year term in prison that would run at the same time as a 10-year term in that motion to revoke your probation case. You have every right to reject this offer and have this case set for trial. I do want to make sure you understand what the possible consequences are and what your options are. And do you want to reject that offer and have that case set for trial? So what we're going to do now, Mr. Guillory, is go through that motion. I'm going to get pleas of true or not true on that motion, and then we'll have a hearing on that motion first at a later date. I'll make a decision on that motion, and then we can go forward with your trial after that, okay? So will he waive the formal reading of the motion?
He does, Judge.
In cause number 22-40982, I have a second amended motion to revoke your unadjudicated probation. Shows that you were placed on probation June 26th of 2024 for unlawful possession of a firearm by a felon, a third-degree felony, and that was a 7-year deferred probation. Is that correct? Speak up, please.
Yes, ma'am.
Thank you. And it alleges that you violated your probation. Count 1 alleges that you committed the offense of burglary of a vehicle June 8th of 2025 in Hardin County, Texas. And is that true or not true?
Not true.
I'm sorry?
Not true.
Okay. Count 2 alleges that you failed to immediately report the arrest from June 8th, 2025 to your probation officer. Is that true or not true?
Not true.
Count 3 alleges that you failed to provide verification of performing the community service hours as required. And is that true or not true?
Not true.
Count 4 alleges that you failed to provide verification of participating in an education program for your GED. Is that true or not true? Count 5 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy, the MRT program.
Not true.
Count 6 alleges that you failed to pay your court-assessed fees as directed, and as of June 16th, 2025, you were $1,140 behind. Is that true or not true?
True.
And then it says second amended, but it never said first amended, so I think it's probably what we were all thinking it was. Anyway, count 7 alleges that you committed the offense of aggravated assault with a deadly weapon June 19th of 2025, and is that true or not true?
Not true.
Count 8 alleges that you committed the offense of evading arrest or detention with the use of a vehicle June 19th of 2025. Is that true or not true?
Not true.
Count 9 alleges that you possessed a firearm on June 19th of 2025 in violation of your deferred adjudication order. Is that true or not true? All right. So did you enter your plea of true to count 6 freely and voluntarily? All right, then I'm going to find that count true, find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that today. I'll reset it for a hearing and ask the probation department to do an updated report. Mr. Coleman, does the state anticipate witnesses with regard to those the offenses that are alleged?
Yes, Your Honor, at least a couple of witnesses.
So we'll set it on a date when we're not in trial, not a docket date, so that we have time to have that hearing. All right? You can go back with the bailiff. All right, ma'am, you're Victavia Sanders. And Ms. Sanders was previously here in cause number 22-39884. Entered pleas of true to counts 2 and 3 and a motion to revoke community supervision. I received an updated pre-sentence report. We're here for a sentencing hearing. Has everyone had an opportunity to review that report?
Judge.
Yes, Judge.
Are there any additions or corrections to the report?
Your Honor, my concern, I guess I can address this after Mr. Smith had the opportunity to present evidence on the new offense, was that the recommendation appeared to be predicated on an assumption that the new offense had been proved up, and that was going to be my issue with the pre-sentence report. Of course, if Mr. Smith is prepared to prove it up, then
Okay, let's go through that.
the necessity for me to go into that.
All right, we'll go through that first. And it's my understanding, and we spoke earlier, kind of off the record, that the officer involved is unavailable, but that Mr. Smith has his body cam video footage from that date, and there's no objection to him putting that on as evidence in this hearing. Is that correct, Mr. Kimler?
Yes, Your Honor, that's correct. My understanding is due to the exigencies of the officer being involved in the shooting, he's on administrative leave and is unavailable to testify. I therefore don't have any objection to the body cam being played in his absence.
Thank you, Mr. Kimler. And just let me know when you're ready, Mr. Smith. And Ms. Lopez is here. Thank you, Ms. Lopez. And at the appropriate time, if you have anything to add as well, I'll give you an opportunity to do that. And so the allegation in count 1 that was not pled true to or not is the allegation of a new theft of property from July 31st of 2025 here in Jefferson County.
He's got to play the video.
Stop. You're being detained. Man in the back, please come up here. Hey, you're being detained, okay? Okay, we'll worry about that in a second. Just come over here so we can talk. Okay, so you're not under arrest, you're just detained. And so I can... I thought she was detained right now.
She just took everything out and dumped it on the floor back there. Yeah, put your hands behind your back.
Wait for everything.
Once already.
And just stay here.
Do you have any other merchandise on your person?
Anything illegal underneath you?
They can take this. I gotta go walk out the store. Yeah, we did. I watched you on the camera. What? I watched you on the entire time.
What we're doing, look, if you have anything illegal, look at me. Hey, let's just look at me. If you have anything that you didn't buy, just send it on the counter.
Can you text this out to me?
Not at the moment, no, because
I'm talking about.
where you're acting like a fool.
Oh, no, I'm not gonna do that.
You act
So,
like a
I
fool.
promise I'm not.
Just like so, just put it all right here. Nothing else in your pants or anything?
No.
All right, let me.
All right, any other evidence with regard to count one?
There is also the footage from the inside of the car where both are detained, where she actually speaks to the other defendant without the cops being there, and she talks about how she was here and you had told her not to do this anymore. But I think that first video kind of sums everything up.
All right, any evidence with regard to count one before I make my finding?
Evidence, Your Honor, is in testimony.
And anything that could,
I'm looking at this trying to figure out if that's a legal search. I mean, she appears to be detained, so it's not a Terry search. It's a warrantless search, obviously. She's not under arrest and being searched at the jail.
they didn't search her. They said, if you have something, take it out. She took it out and she placed it on. They didn't even have to get to the search.
I guess she could have refused and remained silent.
But she didn't, and
She
so,
followed the direction. And there's no Miranda issue since she wasn't
right.
arguably in custody. I don't have any argument. I will go ahead and object if that's an illegal search.
All right, that objection's overruled. I am going to find count one true. And so, let me see, I need to. Counts 2 and 3, she pled true to, so there's a finding of true. Count 2, again, everyone's had an opportunity to review that pre-sentence report. Mr. Kemmler, you may make argument with regard to
Yes, Your
punishment.
Honor. At this stage now that the state has offered evidence as to count, as to the new offense, and the court's found that to be true based on the evidence, I think that the recommendation comports with the state of the record. I would, again, defer to the probation department, but I think that they're seeming to indicate that the court is to keep her on probation, that she enter into the ISF program, cognitive track, and I would defer to that recommendation in lieu of revocation.
Mr.
Or proposal, I suppose, I don't know if it's the next word.
With the pending charge of this theft, she's not eligible to go to ISF.
If I may, she's set on that today. I can resolve that today in this.
No, it's pending in felony.
It's here,
Oh,
it's
is it here?
mine.
Okay.
Because it's a prior
All right.
thefts.
All right.
She's done with misdemeanor
Right.
thefts.
We could resolve that perhaps today, Your Honor, if the court.
I mean, I'm, go ahead.
The
What would you-
state, I feel like we have given her every possible chance to rehabilitate, and she has not taken that. We would ask that she be revoked and given, based on the number of thefts committed, that she be revoked and sent to the state jail for 2 years.
Ms. Lopez, do you have anything else to add to your updated
I put
report?
everything in my recommendation.
All right.
Do you want to address the judge?
Yes. I feel like I did, how can I say this? I feel like I can finish my probation off because of the simple fact, like, this is the longest I've been away from my kids besides when I did 8 months, but they was younger than me, and like, I was younger, and like, they understand what's going on. And I understand, and like me being away from my kids right now is really hard, because they be with my mama, and my mama had dementia, and she.
Stop with everybody else, because I'm not going to make my decision today based on the fact that you have kids or based on the fact that your mom needs you, because you weren't thinking about that day. So don't put that on me,
No.
that if I send you to prison, that I'm somehow going to be hurting your kids or hurting your mom. You've done that. You were on felony probation, and it sounds like if the other video was played, you knew exactly what was going to happen. If what Mr. Smith is saying is true, that y'all were in that car and you said, Judge West said, I better not do this again, and you did it again, it just makes me look like an idiot. for giving you the opportunity in the first place. At some point, you have to stop. At some point, you have to stop. Anything else?
Judge, even based on what she told probation is, she wants to be reinstated on probation. She was just with the wrong person. The girl she was with already took probation. I
Right.
wasn't the one stealing.
Yeah,
So she
I made a
doesn't
note of that.
Accept responsibility.
This is my responsibility.
You accept your responsibility now that we saw it on a video. You didn't accept your responsibility. You said you were with the wrong person. I'm gonna tell you like I tell everybody else. You are the wrong person. She was with the wrong person. Y'all were with the wrong, you're all, if you're in there doing it, you are the wrong person, right?
Yes, ma'am.
So you didn't take responsibility. You haven't taken responsibility. You were given this opportunity after having felonies and going to state jail for the same offense, and I gave you a probation, and I said, don't do it again. So at this time, I'm going to find again, count one, that there was sufficient evidence to find count one true, find it true, find that you pled true to counts 2 and 3, find sufficient evidence to revoke your probation, and at this time, revoke your probation, sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to,
I'll get the other one worked out today.
okay, I'll hold it while y'all do that, and then while I'm doing that, I need a, yeah, I'll hand you the trial court certification in just a minute after y'all do that on this case that shows this was not an agreement. You have some limited rights to appeal. If y'all want to go visit about the other one, I'll hold it. All right, go ahead, go back that way.
Yes, ma'am.
And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Sanders, in cause number 25, DCCR 1351, you're charged with the state jail felony offense of theft of property with previous convictions, and that is from July 31st of 2025. The indictment alleges you were previously convicted of theft November 13th of 2017, and then again April 15th of 2019. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? I have some documents here on the tablet. I guess it's coming. The documents on the tablet that have your signature on them that the state's marked as exhibit number 1. Did you go over those documents with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
Why is it less than what I just
Cost of
did?
back time, maybe, I think she has less back time in the new case.
All right.
Just so it lines up on the release date.
It's Christmas.
It's Christmas also.
We'll go with that. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Sanders is not competent?
There's none to my knowledge. Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find those prior counts true. Find sufficient evidence at this time to find you guilty, and at this time find you guilty of theft with prior convictions. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. It will run concurrently, which means that together at the same time with the other case. I've handed you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. And I want to make sure you understand, don't go do this time and get out, keep doing the same things, because it can get worse. Today, what could have happened is the new case could have actually been stacked on top of the other case. I could have given you up to 24 months on one and then stacked the other. So you already know now, We're not playing games. You've got to stop, okay? All right. You go back with the
Your Honor, for the record, as part of the plea bargain, she's waiving appeal on F-22-39884. So
Okay.
we're waiving the appeal.
Thank you, Mr. Kimler. All right, you can go back with the bailiff.
Conversation.
I know, I almost wish that we had done it just for,
Because they're giving the wrong name and date of birth to the cops. She told them she was a juvenile, she was only 16.
Well, and you know what? Now that you did that, maybe I should have, because it might have been worth it. Her last was 8, so I figured. Okay, what are we doing here? This is, an MTRP?
Yes.
All right, are you Latrick Williams? And will your client waive the formal, oh, never mind. I just remembered what we were doing. All right, so it's cause number 24 DCCR 1791. Mr. Williams was on probation, on a deferred probation. Let me just go back so I can put everything correct on the record, for theft of a firearm, which is, everyone agrees at this point, a state jail felony. And the paperwork for the motion to revoke read third-degree felony, and we all just went with that. And I revoked Mr. Williams' probation. He was sentenced to TDC, and it has now come to our attention that that was obviously a mistake, and that we need to get him sentenced correctly to the state jail felony. So with that being said, I would entertain a motion for a new trial, even though it is outside the time.
We would move for a new trial at this point, Judge, based on the corrections.
Any objection to that?
No objection.
All right, then at this time, I will grant a motion for new trial, even though it is outside the time frame to do that. And so what that means is we're back like nothing happened before that. The case is still pending, you're on the probation, but it's like I did not revoke you, so we're kind of starting over at that point where we were just in October, okay? And it's my understanding that you guys have visited and come up with an agreement with regard to punishment for the state jail felony, correct?
Yes, Your Honor.
And so I think to make the record clean, let's go back through the motion itself, and I'm going to get pleas of true or not true. It looked like before it was 1 through 3 and then 5 and 6, and so I'll just read those that you pled true to already, okay? And so will he waive the formal reading of that motion again? And so let me, I'm just going to print it. It'll be easier for me to, oh, thanks. So in 24 DCCR 1791, I've got a motion to revoke your unadjudicated probation. Shows that you were placed on Would the state like to make an oral motion to amend the motion to adjudicate?
Yes, Judge.
Okay.
No objection.
To read?
To read that it is a state jail felony.
Okay. No objection to that. Okay, so again, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 24th, 2024 for the state jail felony offense of theft of a firearm, and that was a 5-year deferred probation. Is that correct? And it alleges in count 1 that you violated your probation by committing the offense of unlawful carrying a weapon May 12th of 2025 in Jefferson County, Texas. Is that true or not true? Count 2 alleges that you committed the offense of unlawful carrying a weapon May 25th of 2025 in Jefferson County. Is that true or not true? Count 3 alleges that you committed the offense of minor in possession of alcohol May 25th of 2025. Is that true or not true? Count 5 alleges that you committed the offense of resisting arrest or transport May 27th of 2025. And is that true or not true? And then count 6 alleges that you failed to report as directed February 10th and May 15th of 2025. And is that true or not true? Did you enter your pleas of true to counts 1, 2, 3, 5, and 6 freely and voluntarily?
Yes,
And because those counts are actually true.
yes, ma'am.
I have some documents on the tablet like we had before that you've done today with Ms. Holmes. Did you go over those with her before you signed them?
Yes,
You fully understand them?
yes,
And you understand if I follow this agreement, you'll be waiving any right to appeal.
yes.
State tenders number 1.
No objection.
It's admitted any evidence that Mr. Williams is not competent.
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 3, 5, and 6 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft of a firearm. Sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I also handed you another copy of that admonishment regarding your ineligibility to possess a firearm or ammunition. I already read that to you last month. I'm not going to read it again. You understand you cannot possess a firearm because of this conviction in Texas, right? Okay, you can go back with the bailiff. Thank y'all. You need one too?
Thank you. I'm sorry, excuse me.
Good morning. Are you John Willis? And will your client waive the formal reading of the indictment? Mr. Willis, in cause number 25, DCCR 1048, you're charged with the second-degree felony offense of burglary of a habitation, and that's from June 26th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Answer out loud, please. And it looks like the agreement that you've reached is for a 2-year deferred probation. There would be a $300 fine. There would be a dismissal in misdemeanor cause number 25 CCCR 1654, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Speak up.
Yes.
The state tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Willis is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing. Ms. Malfino, what is the state's position with regard to bond?
Judge, I have no objection to a PSI bond in this case. The court will recall that on October 21st of this year, this defendant was before you with respect to a bond. The complainant was also here. Just to be candid with the court, she has been very back and forth, so to speak, about her desire to prosecute or not a misdemeanor versus a felony. I spoke with her again a few times yesterday. This is what she asked me to do, is put him on the felony probation with the court to supervise him. I would ask that in the interim period that we go back to those bond conditions, or PSI bond conditions, whatever we need to call it, that were a no contact with the complainant, a GPS monitor, and the fact that you ordered him to reside with his mom in Iberia Parish at 726 Mergery Street. He's just been unable to post that $7,500 bond that you gave him that day, so he's been in custody this entire time.
Okay, do you understand all of that? And you understand if I reduce your bond today, that those are all going to be conditions of your bond? I understand that Ms. Richards has gone back and forth, and you guys are going back and forth, but until sentencing and possibly beyond that, you're not to have any contact or communication with her. She can't give you permission. I think I went over all this probably at that hearing. She can't give you permission to violate my order, okay? She can't. So, and you're still planning on going and living with your mom in Iberia Parish, correct? So what I'm going to do, Mr. Willis, is reduce your bond at this time to $1,000. I am going to order pending sentencing, if you make that bond, that, and do you think you'll be able to make the $1,000 bond? Okay, so you're going to be ordered to get a GPS monitoring device, and so the bond is lower. You're not going to have to pay a lot to get out of jail, but you are going to have to pay for and keep a GPS monitoring device on until at least until sentencing, just so I know you're doing the right thing between now and then, okay? We'll discuss it again at sentencing. And you're ordered to live in Iberia Parish with your mom and remain in Iberia Parish except coming back to Jefferson County for court, okay?
Can I ask you something?
Uh-huh.
I have a son in Lake Charles. Would I be able to visit?
Yes, you can go to Lake Charles if, to visit your son.
Okay.
So whatever, do y'all have court orders or do y'all just go visit? Okay. So, the main thing is that you're not back here and you're not having contact or communication with Colette Richards, okay? All right, we'll see you back at sentencing. You can go back with the bailiff. Would y'all, I'm gonna print one, if you print the other, please. Same TRPs. Robert Joseph, if you'll print the, somebody print the second one, please. Give me just a second. Get these printed out. Look, I can probably get it before you with your computer.
Pulled it up now.
You got it?
Yes, ma'am.
Okay. All right, well, you're Robert Felix Jr., Joseph Jr., and will your client waive the formal reading of the motion in each case?
He will, Your Honor.
In cause number 21-38610, I have a motion to revoke your community supervision. Shows that you were placed on probation May 8th of 2023 for the first-degree felony offense of manufacturing or delivering a controlled substance. And that was a 10-year term in prison that was probated for 10 years. Is that correct?
Yes.
And cause number 21-38611, I also have a motion to revoke your community supervision. Shows that you were placed on probation May 8th of 2023 for the third-degree felony offense of unlawful possession of a firearm by a felon, and that was also a 10-year sentence that was probated for 10 years. Is that correct? Each of these cases allege that you violated your probation. Count 1 in each case alleges that you committed the offense of public intoxication October 3rd of 2025, and is that true or not true?
True.
Count 2 in each case alleges that you failed to maintain your financial obligation to the GPS device company, failed to charge that as well, and is that true or not true?
True.
And then count 3 in each case alleges that you're behind in your court assessed fees. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 in each case freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true? In both of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I go along with this agreement today, that you'll be waiving or giving up any right to appeal? Do you also understand, if I go along with this agreement, that this is a huge opportunity based on your history and what you're in here for?
Judge, if may I provide the
Sure. Yes,
explanation
ma'am.
to the court? I certainly agree with what the court just said. I know this defendant from his being here before. He's not somebody that needs to be in this courtroom. He's 18 hours shy of college degree. He was a college football player. He got totally off track.
Yeah.
And has just, I've spoken with him in the back. I've spoken with his probation officer. She asked that the court consider this sanction and allow him to be released for the holidays, with the understanding that the pretty low offer that Mr. Rojas and I had discussed previously is now off the table, that he will be on zero tolerance if the court would allow, that he will have to continue to have that GPS on and show you that he can do what he's supposed to do with it. He was hemming and hawing back there about how much he spent on it, and I told him, in my opinion, he's gonna have to prove to you that he can stay on that GPS and do what he's supposed to do and do what Miss Bradley asked of him, what you asked of him. And if he does that, I'm willing to give him the opportunity, if you are, with the understanding that if he's back, I will ask for the full time.
So, and I recognize you as well, and I know you shouldn't be in here, and it looks like you were doing well for quite some time. And so I'm gonna do what everybody feels like you have the opportunity, your probation officer, the district attorney's office. Because of the nature of the offense and what was going on, at least for some amount of time, you're gonna have to wear the GPS monitoring device. And so I know it's not cheap. You're gonna have to get a job and figure it out. It's very important. It's charged at all times. It's paid for. I've gotta know where you are and that you're doing the right things. If you do that for some amount of time correctly, it's always charged, it's paid for, you're up to date, then you can ask your probation officer to ask me if I'll let that go, and I probably will.
So I can answer directly.
They send me, so I have a box in my office that I get a pile of stuff from probation every single day. Early terminations, requests for monitoring device to be, all of those things. But they're not gonna send it over and ask me on your behalf if you have not done everything you're supposed to.
They told me I had to hire another lawyer.
Well, they can send it over. Now, if you want a lawyer could file a motion, they can send the request over for you. But, and I'll take a look at it and see what all's been going on and talk with your probation officer again about how long you've been on it and what's been going on. If there's any change, I'll let her know. But for now, based on the new allegation, you need to get it, keep it, and then I'll reevaluate that, okay?
Yes.
So this was a plea agreement, obviously, that I followed, and so you've waived any right to appeal. I handed you the trial court certification that shows that, all right? Good luck to you, sir. You can go back with the bailiff. Oh, and so, sorry, I feel like I skipped everything, actually. So the agreement was also for 60-day jail sanction, and that's with credit for time he's been sitting.
Yes, Judge.
And he has you've been in there?
Day 64.
Okay, so, state tenders number 1.
Objection.
It's admitted. Any evidence that Mr. Joseph is not competent?
There you are.
All right, then I am going to, again, follow the agreement and continue you on probation, order that 60 days up front as a, but with credit for it as a sanction in both of your cases. And so you should be released today, it sounds like. Go straight to probation, get everything back in order, and then you'll be fine, okay? All right, good luck to you, sir.
Hey, Judge Witz.
Good morning, you're Jacoby Frazier?
Yes, ma'am.
And Mr. Frazier, it was evaluated for competency to stand trial by Dr. Pond in cause number 25 DCCR 0732. I've received that report and will take judicial notice of the court's file. Excuse me. That report is dated November 3rd of 2025. The finding is that Mr. Frazier is competent to stand trial.
Yes, ma'am.
And is there any other evidence with regard to competency?
No, Your Honor.
Not from the state, Judge.
All right, then at this time, I will make the finding that Mr. Frazier is competent to stand trial. And then, Ms. Holmes, do you need some time to get out and visit with him with that? And
I do know that last time we did have a plea agreement. I believe we had done the paperwork, but then there were some issues where he was needing to be examined.
okay, if y'all want to attempt that, I can hold it. If you want
Okay.
to try to go through it today, then we can take all that into consideration and see if we can get there.
Yes, ma'am.
Okay.
Yeah, I'll try to do that.
Okay, I'll hold it to see if we can get it taken care of. And if you need more time, just let me know.
You're gonna talk to me today?
You still have the paperwork? Hold on. Do you want to talk to him for a minute first? And then,
Yeah, let me.
okay,
check.
go ahead and send it, but y'all visit and I'll hold it for a second.
Hey,
All right, again, you're Jacoby Frazier?
yes, ma'am.
So, Mr. Frazier, I gave you an opportunity to visit with Ms. Holmes about your case. You had already entered a plea of guilty before, and we had come back for sentencing, and then I wanted you to visit with that doctor to make sure that you understood everything.
No, I understand.
And so do you want me to go forward with your sentencing today and give you that probation that y'all talked
Yes,
about? Any issues, Mr. Coleman?
No, Judge.
So, Mr. Frazier, I'm going to follow the agreement that you made previously with the district attorney. Find that you entered your plea freely and voluntarily. Again, find that you are mentally competent. Sentence you in accordance with that agreement. I'm going to defer all proceedings for a period of 4 years. You will be ordered to pay a $500 fine, and you're going to be ordered to follow all of the rules and conditions of probation. Part of those conditions are that you follow through with any treatment for mental health care through Spindletop. So if there's classes or counseling or medication, whatever it is, that's now not just part of what you probably need to do, but it's part of your probation. You understand?
Yes, ma'am.
So if you don't go to your appointments at Spindletop and you don't take your medicine like you're supposed to, then it could end up with your probation getting revoked, and you could go to prison for up to 10 years. Do you understand?
Yes, ma'am.
So it's very important that you do everything your probation officer tells you, okay? So I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Obviously, it needs to be on the mental health caseload as well. Yeah, it was already done. And so you'll be released from jail today. It's very important that the first thing you do is go to the probation department. The probation officer is going to talk to you today here in court. She's going to tell you where you need to go, and you need to make sure you try to get there today, okay?
I will.
Okay, good luck. You can go back with the bailiff.
Can I have the paperwork where the probation?
She's going to give it all to you. She's going to give it to you. You'll have everything in writing.
Thank you, Miss Harmon.
You're welcome.
Thank you, Judge West.
Yes, sir. You're welcome. Happy holidays, Mary. God bless.